All right, case number 21, CR 156, Dale Howard, Roger Fillmore. Hearing being conducted by Zoom, and Mr. Wagner is appearing from the jail. And you are Roger Allen Fillmore there with Mr. Wagner. Okay, Mr. Kay, the prosecutor is appearing Zoom from the prosecutor's office. Mr. Wagner, your client is able to this hearing being conducted by Zoom rather than occurring in person before court. You're agreed with that, Mr. Fillmore? All right, the defendant is charged with cheating stolen property, a fifth degree felony. Hearing is set for trial date on this. See. Oh yeah, that's right. What's that? Set for June 13th now. It was enacted because of the failure to show currently. Yeah. All right. Court's been presented with a plea of guilty for Mr. Fillmore. In this case, to plead guilty to receive stolen property, a first-degree misdemeanor. It is a 2-page form. I'll hold it up to the camera, and it has your name and case number, and on there you see the plead guilty misdemeanor. All right. On page 2 are signature lines. About halfway down the page, there's a sentence that says they had to plead voluntarily. Immediately below that, there appears to be signature Roger Fillmore. I'll hold that up to the camera. Is that your signature there? Ladies, you sign this agreement, Mr. Fillmore. All right. When you sign it, Mr. Wagner go over everything with you and explain it to you before you signed it. And did you understand that it was agreed to plead guilty, which means it won't be a trial? The next step in your case will be a sentencing hearing. Okay. And you feel you have enough time to fully consider this matter before making this decision to plead guilty? And are you entering into this agreement to plead guilty voluntarily? Right now, the agreement states that you are going to plead guilty to the first-degree misdemeanor, which I assume is going to be by believing the value alleged.
Yes, sir.
Okay. And so currently, you're charged with felony, which carries possible prison term of 26 to 12 months, fine $2,500. First-degree misdemeanors carry a maximum penalty of 6 months in jail and a fine of $1,000. You understand? And that would be the county jail, not a prison term. You understand that?
Right.
All right. Now, are you serving any other sentences in the county jail at this time?
I am.
All right. And are you currently on community control, probation, parole, or post-release control from any jurisdiction?
Just another day on misdemeanor probation with this county.
Okay. Well, if you're convicted of a criminal offense, in this case, that may, I don't know what the terms of that are, but it may constitute a violation of community control or probation, which means the judge in that case could possibly revoke your probation, which you would have to understand that.
I didn't know. I made it aware in this period that was set in full day here the other day, and I made him aware of it, and he said he just wanted to continue on that probation now.
All right. All right. So now under the law, I'm not required to sentence you to prison for less than 180 days and 6 months. I can impose what's called community control or probation, which means that instead of being sent to jail, you would be put under supervision of the probation department for a period of up to 5 years of the terms set by the court. If during that period of time, the probation department felt that you were non-compliant, they would file a written notice at the court. There would be a hearing. You'd be entitled to have an attorney, and the outcome of that hearing was that you failed to comply. Then at that time, the court would revoke your community control, sentence you to 180 days in jail, $5,000. You understand that?
I do, Your Honor.
All right, so the charge as amended reads that on or about August 23, 2021, County, Ohio, you did receive, retain, and dispose of certain property, being a dump trailer, property of another called Callister, and that you do have legal cause to believe that obtained permission of theft offense. And so that's how it reads now, it's been reduced, which is a violation of 2913.51 revised code, first degree arrest. Now, Mr. Fillmore, you understand what it is, the state is accused you having done, and where, how they let you did it?
For the most part, yeah.
Right, and you understand the possible penalty for that offense? All right, now, have you discussed the evidence of the case, the legal issues of the case, possible offenses you might try to raise your trial, possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
I am.
Are you under the influence of any type of drug or alcohol at this time?
I am not.
Any threat made to issue plead guilty here today?
I do, Your Honor.
Now, on page 2, there's some 3 lines that are printed in bold and underlined that read as follows. Defendant letter pleaded guilty to the amended charge of receiving stolen property misdemeanor, first degree. State defense strongly recommend committing control, penalty, pay restitution, Paul McAllister, the amount of $214.50. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to issue plead guilty here today?
I have not.
Does anyone threaten you to issue plead guilty?
No, sir.
Now, under the law, Mr. Fillmore, the recommendation of the parties as to sentence is not binding on the judge. So if you plead guilty, I don't have to agree to sentence or give you plead control. Probation could, in fact, give you up to 180 days in jail, fine you $1,000. You understand that?
I do, Your Honor.
Now, you have certain rights you need to understand before I accept the plea. First of all, you have the right to counsel. Mr. Wagner is appointed to represent you. That's not simply work the case out, but provide any defense is able to under the law which you provide. So if you decide you don't want to do this, if you want to defend against the charge, we'll continue to represent you, including in trial, if that's what you want. You understand that?
I do, Your Honor.
Under the Constitution, in this case, you have a right to have a jury trial. Mr. Fillmore, which would be 8 people who would be selected from a group of citizens that live in this county that are summoned for jury duty under the trial. After they are selected, the evidence will be presented, and the judge will instruct them on the law, and that jury will have to decide by unanimous verdict, between all 8 have to agree on whether the state proved your guilt. If you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you'd have only a court or bench trial, meaning the judge would be the one to hear the evidence of the jury, the judge would apply the law, and the judge would be the one to decide whether or not the state proved your guilt by proving beyond reasonable doubt. Do you understand that?
I do, Your Honor.
Now, under the Constitution, you have a right to have your, you have a right to confront witnesses against your open court, and to have your attorney cross-examine. So what that means is that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else in the presence. After the prosecutor is done asking questions, your attorney asks questions, that's called cross-examination. The purpose is to bring out evidence that helps your side of the case. You understand that?
I do, Your Honor.
Now, under the Constitution, you have a right to use the power of this court, and power of course will come into court to testify for you, just like the state. So if the witnesses that you have are not going to come in voluntarily, you're not certain of them, then the court will issue at your request a subpoena, which is a court order, that forces those people to come to court and be able to testify if we have a trial if we want them to, even though they don't want to be here. This is the same way the state's witnesses are forced to come into court and testify against you. You understand that?
I do, Your Honor.
Right now, under the Constitution, you have a code against self-incrimination, which means you're not forced to give evidence against yourself at any time, including trial. No one can make you testify. The prosecutor can't, the judge can't, it's your decision. And if you decide not to testify, the fact that you did not testify, not used against you in any way, by any person at any time, no one can comment about it, except in one situation, and that is if there is a jury trial and you not testify. The judge entrusts the jury that because that's your right, they cannot consider it for any purpose. You understand that?
I do, Your Honor.
All right, now, under the Constitution, you have a presumption of innocence, which means you cannot be forced to give evidence in this, I'm sorry, which means state to prove you're guilty. Burden of proof is not on you to prove that you're not guilty simply because you're accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you present any evidence at all in your trial or not, the burden of proof will remain on the state of Ohio to prove your guilt on every essential under the offense charge by proof beyond a reasonable doubt, which is the highest burden of proof is known under the law. You understand that? All right, now, originally you pled not guilty to the indictment, which denied the allegation, denied committing any crime, and exercised all of the rights that I just described for you. If you change your plea from not guilty to guilty, that is the complete opposite of not guilty. The guilty plea admits the allegation, amended indictment now is a misdemeanor, admits it is a crime, and that you're going to commit that crime. That plea wagers up all the rights I've just described for you, except your right hand attorney, which you always have. Other than that, your plea of guilty wagers up the right to have a jury or court trial, wagers up the right to confront witnesses against you, an open court cross-examination for your attorney, wagers up your privilege of self-incrimination because if you say you're guilty, that's what you find you guilty, wagers up your presumption of innocence because if you say you're guilty, the state's not required to find you guilty. It also subjects you to being sentenced immediately by and finally, it wagers up the right amount of appeals that you may have had up until this point in the case. Now, I should sentence you maximum sentence or other circumstances to file an appeal. Other than that, file for 30 days, your sentence is being filed. Do you understand that? Now, are you a U.S. citizen, Mr. Fillmore?
Correct.
All right. Now, do you have any questions about the charge or the possible penalty as amended?
No, sir.
You understand it? Do you have any questions about the plea agreement? You understand it? Again, you understand the recommendation is the sentence is not binding on the court.
I do.
Do you have any questions about the constitutional rights of the claim?
I do not.
You understand those? Any questions about the plea of guilty, what it means, what will happen at the end of that plea here today?
No, sir.
You understand that?
Yes, sir.
Do you have, is there anything you'd like to speak to your attorney about before we go any further?
I don't believe so.
Do you have any questions at all about anything I was explaining to you here this morning?
I think that's it.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge of the indictment of the lesser offense of receiving stolen property under 2913.51, a first degree misdemeanor?
Yes, sir.
All right, then as to the charge, which alleges that on or about April 23, 2021, Highland County, Ohio, you had received, obtained, or disposed of certain property being a dump trailer, property of another, and that you knew or had reason to cause to believe that obtained your permission of theft offense, violation of section 2913.51 of the Ohio Revised Code, the charge of receiving stolen property, a first degree misdemeanor, carrying possible jail sentence of 180 days, and a fine of $1,000. How do you plead? All right, the court finds you on this date of the court defendant will advise of all his constitutional rights, making no intelligent alternative way of the same set of below. Please accept the moral file defendant found guilty of the charge as set forth in the amended indictment. All right, is there, court will go ahead and proceed with sentencing for lists of misdemeanor. There can have to stay.
Only those contained in the plea agreement, Your Honor.
Wagner?
Your Honor, I would ask for the, as I find probation, he's got about 5 days now since he's been given up. I'm not sure we have the works prior to that. He's estimated on an additional 5, so really arguably it would take 10 days to get one. Excuse me.
Fillmore, anything you'd like to say?
No, Your Honor, I don't believe so.
Now, according to the sheriff, there was jail time credit runs for September 16th, 1 day, and then the rest of 5/7, so that'd be 6 days today. Did he have some time in Greenfield or something before he went to the county jail?
Your Honor, I'm not disputing what the court's looking at. He doesn't indicate to me he thought he had about 4 or 5 days here. And I can look into it.
Now, let me see what it says here. He was arrested on the indictment on September 16th.
He should be the same destiny for
Okay. Okay. And he was given no R bond on that day. So we only had 1 day, plus problem on May 7th. Okay. So why did you take off and not come to court, Mr. Gilmore?
In all honesty, Your Honor, I thought it was a Zoom meeting. I called and talked to the clerk, and the month of December, last week of December, and she said that there was an issue with your family that they had just come because I had not received a link to have the Zoom meeting hearing. I didn't realize that I was supposed to be there. She told me, I gave her a new email address and everything, and told her that I didn't have access to my old email address because I lost it. She stated that she would make sure I got the link and everything, and Mr. Wagner called me 5 minutes. But he stated that he tried to call me that weekend, but I didn't have the same phone or nothing. Like I said, I had a different email address that I took with her, and she stated that she would make sure I got the link. But I guess somewhere along the line there, I was supposed to be there because it was changed from the regular meeting hearing to a plea hearing. And I was not aware of that. And Mr. Wagner called me, I finally contacted him, got in contact with me 5 minutes before I was before. And I had no vehicle, I don't have a driver's license, I didn't drive, but I had a way of getting there in 5 or 10 minutes. I kind of should have probably turned this in prior to this. But my friend had an elderly friend that developed lung cancer. Mr. Wagner also represented him, John Freed. And he came to me and asked me if I wanted to stay with him and take care of him. He had no other family, no friends, nobody. And I stayed with him for about a month and took care of him until his last breath. That's the only reason.
Well, I'm not talking about the court date in December, but you were scheduled for a court date January 3rd. That may be what we're talking about. But I also had a report from probation at that time. She had not reported since December 21st. And there was a warrant issued also for your failure to appear in this report on December 27th. And you've been testing positive multiple times for controlled substances, meth, cocaine, amphetamines, and then 22nd and 27th were your closure report. Didn't. So, and then here it is, May 7th before your final time. So you did nothing to try to fix this and come before the court. You just waited until you could talk. So, it is the court that should be placed on control for a period of 2 years in the supervision probation department, primarily because I want to see this restitution paid. Here today, all laws, all jurisdictions, conduct yourself in all line manner at all times. You report when and as directed, you prove all statements you make to the probation department about your conditions, keep it informed of your residence place employment at all times. Not change without prior permission, not leave the state of Ohio any time without prior written permission. There's one to manage the pressure facility in a jurisdiction, or may you communicate with the inmate in those facilities about prior information. Not the person possess own, use, have, or control any kind of firearm, ammunition, snake, dangerous source, weapon of any other type. Do not purchase, possess, use, have, or control substance, drug abuse, CBD, oil, freight, or any varying analog, any controlled substance has effects similar to that, or any device or thing may be used to administer them, prepare the administration, unless you have a lawful prescription, copy which must provide. You're also subject to drug testing when as directed, not to purchase, possess, use, have, or control any kind of alcohol beverage, or may be present places where solely being considered as unlawful. You are not associated with any co-defendant, in this case, any or any other person in the criminal record, either gang or any person who could in the future or has in past past violate this condition. Now, after the date of this order, marriage shall have cohabitation, all marriage type relationship with another person of the commission. Report and contact law enforcement, arrest citation, which of the charge violating law, while later measures that occurs. You're providing your supervising officer financial information records to report paying fines, fees, and possibly review. If you're referred for evaluation, assessment, any kind of treatment, therapy, counseling, training, or other education program, you submit that. And if you're syndicated to enrollment, follow that for dependency of this action. Your pay restitution to following counselor in the amount of $214.50 as we paid through the Island County Victim Restitution Escrow Account Victim Program. We paid the fee associated with that. You're also going to pay the court costs and maintain arrangements to do that for clerk. And make monthly payments on that. Restitution will be paid in full by February 28, 2022. Looking at your history on pretrial supervision, as well as your prior criminal history, and the total BS that I just heard about why you didn't report or do anything for the court, this order the court that you be required to serve 90 days in Island County Jail, get credit for 7 days, no good time credit from the sheriff. Now, being placed on community control rather than being sent to prison or to jail, the full day, term, 180 days, redeemed with sent to a search without a warrant of your person, vehicles, residence, or any property or place the vehicle is under control where you're not any nominee officer of the probation department. There'll be no fine levied at this time. And if you don't make payments on the court costs, the court can fact at various means to levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court will review your service and give you credit for each hour you work and an hour the rest set by the court. And each hour you work will reduce your judgment by that amount. They'll pay you in full. Now, any event that is alleged you fail to comply with these conditions, the probation department will file a written notice out of court. The court will conduct a hearing, and the outcome of that hearing is that you have failed to comply. At that time, the court will revoke your community control and sentence you to full 180 days, give you credit for 90 days which you're going to serve as a condition, and also then at that time, finding without the law. All right, is there anything further from counsel?
The only thing, Your Honor, is that you said restitution paid in full by February 28th, 22.
Oh, sorry, 23. Thank you.
Nothing else.
Wagner, anything further?